You have to set it all the way up again? Okay. Make sure.
Ready to roll.
All right, have a good night.
I appreciate it.
Absolutely.
We are.
No.
No?
Well, not likely.
Okay.
It'll be dependent upon what everybody else. So,
I can't, correct?
correct. I mean, you can, but I wouldn't recommend it.
No, I mean, initiate wise.
Hmm?
Initiate to take it off, if that were the case.
Hey, how are you?
Good.
Hey!
You ready for Friday?
I've got the invites here. You got one already, right?
No more batteries.
I hope we're gonna have
You hope you're gonna have what?
good weather.
Is it not supposed to be?
Oh no.
Well, I guess we'll keep an eye on it.
Yeah, well, we still are holding it.
Yeah, no doubt. It should. It's all for the cause at the end of the day. So
I was here. Yeah. I was like trying to figure out what we were gonna talk about.
he's out of town.
Hmm.
How are you doing?
Good.
Good to see you.
Good, how are you?
I was wondering if it's in the public meeting, if something comes up that I don't agree with, and you have some information about it, it's okay. Commissioner. It seems like, yeah, okay.
Trustee,
Just wanted to check.
You can always, there's no conflict with any.
Hi,
As of right now, you're wearing.
how are we doing?
Public, exactly. Thank you.
Oh, yeah. Oh, yeah. Is there any visitors? No. Delivering the notes. Here.
Well, they're not paying, they're trying to make money on it.
Last night I heard if they wanted to drink, we're gonna try.
Yeah, we actually, I think we were gonna ask. So we work.
Ask them to help as part of the discussion stuff that if they want to.
No, I mean, also help like, if they come.
Make my life easy.
The teach things. So I didn't give them a teach student, I'm gonna be a teacher.
Hey, Gloria. Good, you? Another day, another dollar.
How are you? Not much. Good. How about you? Don't you feel like?
I know what I signed up for, so we're good.
You were aware of what you signed up for?
Yes.
Sure about that? Just kidding.
Right. Now the extent.
Yeah. I'm sure you have been appreciated, even for you.
Oh, yeah. Yeah, it was, you took it off of there? Yeah, because I had a little red battery showing. So, yeah, so I just threw it back on there real quick to give it a little bit, just in case. guess I can go grab real quick because we're waiting for Stephanie.
Well, he repainted, that everything's gone off the wall, because he repainted it. Yeah, that's a lot.
Oh no.
Yep, we're live and.
How are you doing? How are you doing?
I just, the days sneak up on me, that's for sure.
I know, it's already gonna be the end of the year.
I know.
I feel like I just started. Ugh. It gets so clammy in here. It gets super cold and then hot.
Hey, I have a present for you guys. For you guys. Because these are gonna expire. That one isn't too good, but yeah, they're saying she
Okay, let's do this.
Just switch them just in case. Yeah. Better be safe, sorry. Trustee, how are you today?
Mm-mm. No, sir. I mean, no, ma'am.
You just have to know.
Which would be this? No, no. Oh, yeah. It has to be.
Well, what you can do, it's not the first one.
Yes,
Okay.
yes, it's similar. Yeah, I did that.
That's
So,
okay.
I'm Mary. So, anyway,
Yes,
you should be able to tell, because it's not a calendar. Right, I do that, but I haven't done it. Okay.
Oh, yeah.
Just 32.
Cynthia gave us.
I'm here.
Well, Cynthia was here.
How are you?
Janice and it's not Janice, right? Yeah. Monica's bringing a friend. So these are for you.
The one at,
Thank you. Will you agree? Yeah. the one that's- Okay, so we're about turning down.
All the way down. Where did my other? I know I just had it. All right, we'll go ahead and get started here. Today is Tuesday, October 15th, 2024. The time is now 5 o'clock in the evening. We are in the town hall boardroom for a public hearing that will be happening today. I will note that Trustee Nevadas will not be present this evening. So we will be moving forward without Trustee Nevadas while he's out for the meeting. So we will, for this public hearing, what we will be doing is we will be hearing each one of we have 3 cases that are being heard this evening for public hearing. We will be hearing each case independently and individually. With that in mind, everybody that will be speaking, the format for this will be everybody that is that would like to give public comment on this. We'll need to make sure that you're sworn in. And as I mentioned, we will hear each one individually, so we'll do swearing ins for each individual one. With that, we will get background information from the town team, and then also from the applicant, and then we will continue on with the public comments. I would like to limit public comments to, actually, there will be no limit just because of the number of people that are here. There's not a large crowd per se. So is there any questions so far? No? Okay. Our first case that we will be hearing this evening for our public hearing is a rezone case 061870 for 2750 Old Farm Road, submitted by Enrique Vigil and Melanie Altuna Vigil, requesting approval to rezone their property from residential agriculture, or the RA zone, to 3 single-family residential zones, or R1. Eddie, before you give information on this and the background, and we go through, Gloria, if you'd like to and raise your right hand.
Do solemnly swear to tell the truth and nothing but the truth
And nothing but the truth,
to the best of my ability.
to the best of my ability,
So help me God.
so help me God.
Thank you. All right, so we will move forward. Mr. Salazar, as you have been sworn in, you will start the case and give the background information.
Yes, for the record, my name is Eddie Salazar. I'm the Community Development Director of Economic and Community. I apologize, I'm just a little disorganized, kind of last minute things. But this is case number 061870. It is at 2750 Old Farm Road. It's submitted by Enrique Vigil and Melanie Altuna Vigil, requesting approval to rezone 3 acres into single-family residential zone. The zone is currently right now is residential agriculture. Background checks analysis. This case has come before the P&Z and the BOT in the past, approximately about a year ago. Mr. and Mrs. Vigil are reapplying for rezone for their property. Application for rezone with said property has previously been submitted on July 23rd, 2023, and presented to the P&Z on August 21st, 2023. PZAC voted and made a decision to decline the request on September 5th, 2023. The decision to deny was based on the presentation of our green belt and approved by PNZ, PZAC on October 23rd. After approval, it was then mailed to Mr. Rehila as stated on Mesilla Town Code 18.90.130. PZAC's decision was appealed by the applicant within 20 days as listed on Mesilla Town Code 18.90.140. Board of Trustees heard the appeal case on October 23rd, 2023. The governing board upheld the PZAC's decision to deny on grounds of preservation of agricultural zone for the purpose of surroundings our historical core plaza and to avoid modern development merging into our community. Is a priority set forth in our comprehensive plan. Secondly, community water readily available for smaller independent developments, lots 1 acre is concerning. On August 19, 2024, a rezone hearing was held by PZAC. All commissioners were present and heard the case as it was presented by the Community Development Director, Eddie Salazar, and Moy Surveying, Anton Magallanes, representing the applicant. A special meeting was held on October 27th, 2024, and the listed rezone case as on listed the rezone case as an action and consideration for approval. During this special meeting, only 3 commissioners attended. All 3 commissioners voted yes to approve the rezone request. Department comments. PZAC's decision to deny the request in 2023 was based on the preservation of the Greenbelt. As listed in the comprehensive plan and replat, not meeting town code. Approval of the rezone and the second time it was heard was due to the fact that the comprehensive plan is not in our code. Therefore, PZAC to previously deny was to an outreach of their authority. Comprehensive plan mentioned preservation of the Greenbelt, of the green zone. I got a green sound, but apologies. A green zone of 5 acres or more. So whenever the comprehensive plans really talks about surrounding, the plaza and protecting itself from modern structures and such, is really talking about large lots, 5 acres or more in specific. In the back of your board action pack form, you'll see I took some copies of the comprehensive plan that highlighted them where it's specific, where that states. Second reason that it was denied was due to the replat of the property submitted did not meet lot size minimum standards of 1 acre parcels. Whenever the replat was submitted last year, the replat that was submitted was a previous replat that they had already. It was something that they had on file. It was just submitted along with the rezone request as an information of where the property plot was at, as far as proof of ownership and the outlines of the property and such. Not so much for the size of the lot. It's a total of 3 acre lots, and the applicant does understand does understand that they need to be meeting requirement of 1 acre per lot. At that particular time, I think there was one lot that specifically was at 0.88, which we all understood was not will not meet the town code. But at the time, it was specified. It was brought up that right now at the time that we're not talking about subdivision requirements. We're talking about rezone request, and one of the reasons was given that now the applicant has an opportunity to, if he feels like dividing that 3 acres into 2 lots, it will still fall under the residential 1, and he still will be able to conform to meet the requirements for the R1. But again, at the time, the request, as it is today, the request is for approval for the rezone to from RA to R1, so that either he can divide the property into 2 or 3, whichever meets the requirements that he wishes to do. I stand by for any other questions. If you look at the packet, supporting documents, it's a rezone application was submitted. More surveying representing letter, again, representing the applicant. The warranty deed was submitted. Doña Ana County parcel information, map, Rayleigh's acres, community parcels, Rayleigh acres replat of lot 2, attorney recommendations, and then PZAC minutes for those hearings that I specifically just talked about. Some resolutions that were done and sent as per Mesilla Town Code, and pages 42 and page 88 of the comprehensive plan referencing the Greenbelt, as I mentioned, with the large lots and protecting the Greenbelt in the RF zone.
Thank you, Mr. Salazar. We'll hold off on board questions for just a minute if we can go ahead and if you would state your name for the record.
Good afternoon, good evening. My name is Anton Magallanes and I'm with Moise Surveying.
And Mr. Magallanes, you have been sworn in, correct?
Correct.
Thank you.
Yep. When we look at, I'm trying to think of what point in time we want to start this story. Eddie, remind me when our zoning code came into establishment for the town. Was it 1972? 74. I always get that wrong. So we've had land in this town, in this community, on this earth longer than 1974. That's fair to say. And so prior to 1974, these lots were all individually 1 acre lots. So from the beginning of time, at least when they were surveyed, up until that 1974 time, they were all 1 acre pieces. Fast forward a little bit, our zoning code came in and said, okay, we're going to reestablish this area. We're going to provide zone designations for this area. And I'm going to elect to say that even if we said at 1974, zone RA was established, which said this was a 3 acre minimum. The hardest task a planner, I think, probably has to do is to try and designate land use to existing land. You're never going to get that right. And so that were non-conforming. They were zoned to RA, but they were all legally 1 acre lots. You should be able to buy and sell them as you needed to. Now, if you try to build on it, what would happen? And I think that's the hurdle that we ran into. So fast forward to when the Vigils purchased the property, we got to this point where they said they had to replat this if they want to build. I don't agree that was the best approach to solving the problem. At that time, we should have done a zone change. We should have said, it doesn't make sense to replat this, or do we maybe just have a wrong zone designation on this lot? Lots exist in our community today. They exist in the city of Las Cruces, they exist in the county, they definitely exist in our town. And we're gonna have to handle those case by case as they come up for review. So we didn't rezone it at that point in time. They did do a replat to combine it all into one lot. Now, that doesn't solve the problem of spot zoning. So when we look at our town of Mesilla map, there is a clear spot zone issue that challenge already that I think we should work to solve, which I think necessarily aligns really clearly with, of course, our request for our zone change. I want to read this, and this may be the quote that you guys have on the back of your packet from what Eddie was mentioning. Let me see here. So page 42 of our comprehensive plan mentions a green belt. And I recognize that from all of the comments, letters, public appearances, or public comments from our community members, the biggest concern is preservation of our green belt. So then I first stopped to say, what is our green belt? Where is it? How big is it? What applies to green belt and what doesn't? And I do honestly think that until we can really delineate what that means, we're going to be faced with some challenges as a community, because we don't do a good job, not to anyone's fault here, of course, but of delineating what does green belt mean to the community. And so until we really tighten those screws to say it's this lot size, or it's this parts of town, to help the professionals in this community guide development, we're going to be met with some green belt around the town using large lot zoning, which allows for one housing unit per 5 acres. So the closest definition I can find of what green belt is from our comprehensive plan, which we have adopted, stating that it's 1 unit per 5 acres. So I think that at least gives us a basis for a foundation to say, okay, we have an understanding of what it at least might mean to us, because although consultants were probably hired with this, we adopted it as a community. In any capacity, the green belt, I think, quite honestly, we're helping to solve a spot change problem, a spot zone problem. We're consistent with land use around us. I think if they were requesting a 5 acre to an RF to an R1, then we can have the green belt conversation. The other conversation that we're met with from public comment is, we're opening up a can of worms. This is going to establish precedent. This is going to, the next person's going to come in here and think they can do this. This isn't case law. So the decisions today by this body, although people may march in here and say, hey, you did it last week, you have to do it. No, you don't. And quite honestly, development and the experience I've had with the cities, municipalities across the state, every case is handled case by case. That's what makes your job so difficult, because 2 properties across the street could potentially be handled differently. So to the comments that are about establishing precedent and what will this open, unless we have another 1 acre, or excuse me, a 3 acre replatted lot with probably incorrect zone designation that is spot zoned around 2 properties, it should be handled case by case. And the reality is that that's why this board is here, that's why P&Z is here, is to take on those one by one individually, hear the cases, and make the best determination for our community. We know our population of this town, according to at least the comprehensive plan, is maintaining, if not potentially sometimes declining. You know, we see more and more requests for Airbnb rentals, because last meeting that we were at, we had a public comment come in and say, why do we have to split this? Why do we have to split this? It's speculative investment. You know, he was really concerned, and maybe he made some valid points, but his case was also for a request for an Airbnb. So it's when our comprehensive plan was written, and I don't want to be quoted on this, but I believe it said we had something like 11 Airbnbs within our community. I think the last meeting we heard 4 cases on its own. So we can understand that climate's changing very drastically. We know that the comprehensive plan makes notes to say that a lot of our long-term residents may not be here anymore because their homes are being purchased by out-of-towners. So we're in this crossroad where we have lots that might qualify for some good infill development that doesn't really, it's not a 100-lot subdivision, that will align with our comprehensive plan while helping to establish some of the goals, which are, you know, accessibility to housing, helping to provide lower income houses for all income generations, or income levels, I should say, because what we're seeing more and more is that, I mean, we all recognize the prices. And so the request that they're providing at this point is just a zone change to be able to then subdivide potentially to 3 lots for their children. I appreciate Eddie mentioning that at this point, it's just a zone change. So we still have the opportunity to submit our application thereafter for a subdivision. You'll probably see us again saying, hey, we're requesting a subdivision. And at that point, any development concerns can be talked about. But as far as the zone designation, we do have to look at this at a case. It's just, do we in fact have spot zone? Are we solving that problem? Are we in line with the comprehensive plan? Is it for the greater community or the benefit of the greater community? So I think given the justification, the reasonings that we've provided in this meeting, along with the P&Z meeting and prior, I think we're in direct alignment with at least the comprehensive plan and what is best for our community. I'd stand for any questions if you all have any.
Thank you, Mr. Magallanes.
Sure.
Before we move on for questions, we'll open it up to public back and forth if we need to with Mr. Salazar and Mr. Magallanes. So if there are individuals in favor of the rezone, if you would step to the podium and state your name for the record, please, if you have been sworn in. There's no public comment in favor. Okay, then we'll move to opposed. Those that are opposed of the rezone, if you would step to the podium and state your name for the record, please.
Mary Lucero.
And real quick, Ms. Lucero, you have been sworn in under
Yes.
oath. Thank you.
So my only concern is, why is it that we continue, or cases come up before you guys and they continue to go against the ordinance and the code? I know that your motto is to move forward or keep moving forward, or however it is that you say it. But with your moving forward, I see more and more crime. I see more and more traffic. I see more and more unsafety stuff that's going on in Mesilla, where it's a concern, not just for myself and the elderly that live around me, but for my grandkids. With this change, although it says in the ordinance it's not supposed to happen. And I understand, you know, he wants his kids to live by him and all of that. I'd love for my son to live by me too, but because the ordinance says it can't, I respect that, because we need to preserve our town. We need to keep it historic. I don't think that we need to keep moving forward, maybe take a few steps back and get it back to safety. And that's my main concern. So the more people you come in, the more rules that you guys don't abide by. The ordinances were put there for a reason. Please just abide by them. 3 acres, I guess, like it was mentioned. And I get it that the town wants to get more money and taxes and blah, blah, blah. But is that really what's best for the town of Mesilla? That's it. Thank you.
Thank you, Ms. Lucero. Is there any other public comment that is opposed? Even for those that may not have been sworn in, we can still swear you in if you have either pro or con comments you'd like to give.
I'm the applicant. My name's Enrique Villa.
If you want to
Yes.
comment, you can definitely comment, come to the podium. State your name for the record.
Yes, my name's Enrique Vigil.
And Mr. Vigil, you have been sworn in at the very beginning of the meeting, correct?
Yes, sir, Mayor.
Great, thank you very much.
I'm not sure what this has to do with the crime element. I'm a retired law enforcement for the last 30 some odd years. Not sure what we're talking about apples and oranges for the last speak against the rezoning of this property. I'm not sure what that has to do with crime. You know, you can see it throughout the whole nation that population's going to increase. We're out here in the Southwest. We're here lack of water. You see here in Mesilla that there's a lot of farmland out there because there's no water. You go up and it doesn't look good. Now to drill a pump, we're talking over $100,000s of dollars easily just to irrigate your land. And farmers are having to sell. When farmers sell, you mean there's gonna be people moving in eventually. So you can't stop from people migrating into the Mesilla Valley, or especially here to the town of Mesilla. It's going to happen, and we're going to have to deal with it. So I do want to ask that you do consider all this, the factors about the spot zoning. My neighbors, which is a Masonic Lodge, they're zoned residential R1. I'm the only one with a different color up over there, which is spot zoning. I do have legal representation, and they've told me it is spot zoning. The land behind me, which used to be owned by a farmer, Arturo Jurao, that used to be agriculture right next to Mesilla. I'm not sure how that got approved. They used to grow onions, they used to grow cotton and everything, but it got approved. And I think I have a good case before you guys to really consider this. It is spot zoning. So I hope you do consider this. I mean, to allow me to rezone my land into 1 acres. Now, as for the panels, what does that have to do? Panels can be removed. They used to be on top of my home. When we had that real bad hailstorm with a lot of roof damages was caused throughout the whole county. It was years ago. Well, I had roof damage, so they took off the panels. And I told them, yeah, just put them there, because they're going to charge me an arm and a leg to put them back up over there. They're operating. But if that's not a permanent fixture. That's not a permanent fixture. I have the option of taking them, doing away with it. So I'm not sure what that has to do with rezoning too. Once again, thank you so much.
Thank you, Mr. Vigil. Is there any other public comment on this rezone case? I know we did have some members just come in as well. Seeing as there is none, no other public comment, what I would like to do is have the trustees ask questions to either Mr. Salazar or to Mr. Magallanes directly. If you two will take note of questions that are asked, and then I'll have you come up and address those questions or comments as well, and then we will move on from there. So trustees, if you have any questions at this given point in time, or comments as well.
Mr. Mayor, have some questions, please. Let me start with,
Trustee Johnson Burek.
thank you, Mr. Mayor. Let me start, if I could, with Mr. Cesar.
We're gonna, before just ask the question, we're gonna ask the questions as a whole, and then he'll address them.
Okay.
And that way it just,
Okay, sorry. So in the resolution, well, let me back up. So was the planning and zoning given the information that Mr. Vigil was already given a zoning change when he bought the property? So that's the one thing, if they were given the history of that, because this will be the third accommodation for Mr. Vigil. And am I doing questions or comments, Mr. Mayor, or both?
you can do both.
Okay, thank you. And I know that in 2001, when it was rezoned, it says in the minutes that it was to build a home in a pecan farm. And of course, I haven't seen, even in 2005, 2010, there wasn't a pecan tree. So I have concerns with, now we're going to go to R1, and will there really be homes for his family or other alternatives? Because that's been happening a lot. In the resolution, it says, whereas on August 20th, 2001, the said parcel were 3 1-acre individual parcels according to the survey performed by Moy Surveying Incorporated and approved by the town of Mesilla. And then it states, whereas on February 24th, 2007, the said parcel was recorded as 1 3-acre property according to the survey performed by Moy Survey Incorporated and approved by the town of Mesilla. So I guess I just want to make sure that survey in 2007 is a reflection of the vote, the zoning change that was taken in 2001. Because I don't know why it would all of a sudden appear 2007. When it looks, again, I think it was October. And then that's all the comments and questions for now, Mr. Mayor. Thank you.
Great. Thank you.
I'll turn it over to any of them.
No. Any other trustee comments? Trustee Cadena?
First, Mr. and Mrs. Vigil, I mean, kind of hard on you because this is a case that's kind of important. I mean, it's important obviously to you, but to the town of Mesilla, because it's been back and forth and because there's been because the comprehensive plan, even though Eddie and Mr. Magallanes say that it's not the law, it's not the ordinance, it was developed in order to avoid these issues, right? To say, here's our long-range plan so that Mesilla isn't in this quandary all the time, right? And I see that it's a spot zoning. It was pointed out to us over time, and it has been changed, like she said, like Miss Johnson Burek said. But so here's the problem I have with it, is that it's spot zoned because it was asked to be rezoned, or it wouldn't be spot zoned. And it was asked to be rezoned because of the accommodations that you needed at that time, which is fine. Well, as of certain influences having more influence on rezoning and zoning and building things. Mesilla Farms was built without, out of the zoning ordinance, out of the ordinances. Not against anybody on Mesilla Farms. Yeah, you guys wouldn't know about it, anybody that owns anything in Mesilla Farms. But anyway, I mean, just this long history of us just trying to preserve the quality of life in the town of Mesilla. The first comprehensive plan, what we wanted to do with cluster developments is, instead of like Los Reyes did, where there's 10 1-acre plots, that there would be like 9 third-acre plots, so that only 3 acres would be used as land, as houses. They would be a 1/3 acre each. They would be more affordable for regular families. That's what a cluster development is. And then the rest of the acres, which would be, if they had a 10-acre plot or a 15-acre plot or whatever, would be still RF. And that's what the green zone is supposed to be. It's not supposed to keep people from building, keep people's families split up. It's just supposed to be able to give a long-range plan for people to be able to use their land the way they want to, but also conserve the green belt and make more affordable housing. Because a person buying an acre plot in Mesilla and building a 5,000 square foot home, are probably in the upper income, very high income level, where if they bought a 1/3 of an acre with a small 1,600 square foot home, would be more affordable. So, I mean, the first comprehensive plan in the early 2000s sought to do that. No, it wasn't set in law, but the ordinances were and are supposed to meet that goal that is written out in the comprehensive plan. Now in 2017, it got updated or revamped or whatever, and things changed somewhat in it. So I just think that, I mean, as much as I appreciate Mr. Magallanes and Mr. Salazar pointing out the things that they point out, I mean, some of it isn't taken into consideration. I mean, I don't want the comprehensive plan to be minimized as something that is powerful and that we should look at as a very important thing in the development and the preservation of Mesilla. And as far as precedents go, yeah, I mean, we do. That's exactly what one of the arguments is in this, is because Los Reyes was able to develop into R1s, that therefore Mr. Vigil now has a spot zoning problem. So, I mean, I think that you can't argue both sides of that argument, right? I mean, it's in here. So, so I think that needs to be looked at a little bit different. And again, Mr. Vigil, it's just that you happen to have this property and want to do what you need to do on it. Mr. Salazar, so, okay, so we rezone it to R1 so that we don't have spot zoning, and so that it's more compliant and the person gets what they want. We still don't have a 3 full acres, right? Do we?
Those questions right now, sorry.
Yeah. And I'm sorry that I didn't remember that. I wasn't supposed to do that. Okay. I mean, that if you come back in 6 months or a year or whatever and say, hey, we want to build 3 houses, not 1 house for our son or whatever, we want to go ahead and split it up, that we're going to have the appropriate amount, and I mean with setbacks, with everything, not that we're going to be making variance changes in 6 months in order to fulfill the R1. Like, you're not going to come back and tell me that you only have 8.88 acres to build, that's supposed to comply with an R1, with all the setbacks and everything else we need. I would like to know that. I mean, otherwise, I would like a commitment to say, we're going to do 1.5 acres, we're going to do 2 or whatever, you know. And I know that right now, all we can do, I get it, that all we can do is do the rezoning. And we're not talking about what it's actually going to be built there. But at the same time, I feel like we're having to, I mean, that's what we were elected to do here, right? I mean, he said that. I mean, we are supposed to make these decisions that are difficult, and that's what we are elected to do. But we're elected to do it in the best possible scenarios for every person in Mesilla, not just one. And we can't help it if, I mean, this board can't help it if decisions were made and zoning was passed in the past by another administration, or even if somebody was sitting on that administration and still passed it. I don't know. But two wrongs don't make a right. I mean, we can't fix things by breaking other things, you know, our zoning laws. So again, I apologize to the Vigils because I think they're just stuck between a rock and a hard place for that particular situation. But I do want specifics on what the plan is, because, I mean, it's like Stephanie says, on one hand, we want people to do whatever they need to do with their own property, right? We're not, I mean, that's the American way. We want people to be able to do what they want with their property. But we also want to preserve the integrity of the town of Mesilla. And I think what Stephanie says is sometimes, you know, people do come up to us and they're presenting something, and then 6 months later, the plan has changed. And then we end up with something different than we expected 6 months before when we approved it, because it wasn't clear. We didn't ask enough questions, or we weren't thorough enough. So I think there's like one question on the whole thing.
So I think we've had a lot of missteps as far as our ordinance and what we're doing in previous years and previous administrations. And I think this board has done a good job as trying to mitigate those errors, fix those errors, and move forward. But as far as moving forward, it's not a yes or no. It's not one side or the other. It's not building, not building. It's a compromise and trying to find what's best and what fits our entire community, not just one side or the other. So this has to be taken case by case. And in this case, just like our ordinances, yes, we want to follow our ordinances, but it's also our job as a board to fix things that are causing issues, just like we're doing with the short-term rental. We're creating a new ordinance for a new generation and a new revenue stream that wasn't thought of 20 years ago, wasn't thought of 10 years ago. So now we're trying to work through that. So it's not a yes or a no, it's not a right or a wrong. It's how we can fix the missteps that were made and make clear boundaries for what we're doing. And at the moment, he's in a spot that is now considered a spot zone. And I think it would be a lot easier if we created clear boundaries. If we had a 15-acre lot, pecan field, that wanted to be subdivided, that's a different discussion. Saving the greenbelt is important. It's a huge priority. But in this case, we're not talking about 15 acres of land. We're talking about residential right next to farmland. And in this case, he doesn't fit one, but he can fit the other. And we're not making a decision to split it into 3 right now. We're making a decision to clear those boundaries up. And even though, as Trustee Cadena said, these missteps were taken prior to some of us on the board and prior to a different administration. So now it's up to us to try and create those clear boundaries, even though that might have not been something we would have agreed to back then. Question-wise, I don't think I have any questions. I think both of my other trustees asked any of the questions I had. And that's it.
Thank you, Mayor Pro Tem.
Mr. Mayor, I do have
Sure.
some additional.
Trustee Johnson Bjork.
So also in the resolution, well, one, I didn't see in the minutes any discussion amongst the commissioners, the planning and zoning, any discussion that they brought up. And that could be because you're trying to minimize the work on the minutes, but didn't provide me a lot of information to their thought process and why everything drastically changed from last year to this year. I know there are different members. Let's see, going back, it says, whereas property is an isolated parcel designated as RA, there are no similar parcels adjacent to it. Mesilla zoning map shows numerous residential single R1. I don't know if there's numerous located in very close proximity. The last statement, now therefore be resolved, et cetera, that it is in the best interest of Mesilla. I don't see anything on this resolution that leads me to believe that this is by far the majority for the town of Mesilla in the best interest. I'd see it's in the best interest for one person. And again, this will be the third rezoning to accommodate set-in applicants to conform to what they want for the property. And yes, I know people are going to be moving in here and migrating to our community. And yes, it's bound to happen. But one thing that's not going to happen on my watch is that I'm going to let said people moving in destroy this green belt and destroy what has been in place for over 80 years plus. That's not being 6 generations. I'm not going to be threatened by where it's going to happen. And again, that's why I'm up here doing my best to make sure that it is not going to happen on my watch. That's all I have. Thank you.
Thank you, Trustee Johnson Bjork. Before we move forward, I do have one thing myself that I just want to ask. It's kind of for Mr. Salazar. And in this, what we look at here is, in the pack that's been provided, we have a original plat that dates back to 1982 with some of the changes in here. One of the things that I find interesting, and I think that some of the comments earlier when we were talking about cluster zones and or cluster subdivisions and the percentage that's required for a cluster subdivision. So I believe it's would be 80% on that. So one of these replats here that we have has a total of 24.52 acres total for Rayleigh Farms. So I think that the question really is what when we look at what is 80% of the and what we're looking at it is, I just did the math here, is 19.6 acres would be 80%. So if we think about that as a cluster subdivision that might have been done back then, because this does have the administration signing off on that replat back then in 2007. So I think that and I just want you to touch on that, five individual acres, as it was mentioned earlier, with the remaining staying, the remaining 80%, which would be up to 20 acres, staying in that in the rural farm zone or the 5 acre minimum. So because that's when I look at it, that's what this appears to. So with that noted, other questions right as of this moment. Mr. Salazar, if you will first come up and address the trustees' questions and comments, that would be great.
Okay, Mr. Mayor, this question is for Trustee Johnson Bjork. I didn't quite understand the question, but you mentioned that if the P&Z at the time when they heard the case the first time, if they had all the information as they have today, is that what it?
The last,
Yes.
this most recent.
Okay. All right. So now this is for one, you did mention we do have some new members on the commission, and also the difference why it was denied in the beginning and then why it passed this time around was due to the fact that the Greenbelt, and again, it mentions in the comprehensive plan about building that cushion.
I'm sorry, but going back, where they provided that information that we got?
Yes.
Okay,
Yes.
okay, sorry.
Okay. So I guess what I'm trying to say is the new commissioners and the Greenbelt comprehensive plan as large lots of property to surround the plaza to protect our historic landmarks or zoning. The previous commission does not look at it that way. They seem to think that, again, they're subjective, like you all should be, right? To interpret the code to your understanding, is that the Greenbelt is more about protecting agricultural lands in the sense, right? So again, that is the difference I think that happens between the first time the P&Z was there and now we have new commissioners that are subjected to how they see the interpretation of that code. The lots on the 2007 vote, the parcel that you mentioned that is on there, it wasn't a vote that's when that happened, but that's when the survey was submitted, okay? And Mr. Magallanes, Moy Surveying, mentioned that I think it's, let me look at the survey here. Make sure I got my dates right too. So I was kind of trying hard to listen and write at the same time to the next commissioners.
I guess my concern is that it wasn't approved on that date.
I'm sorry?
It wasn't approved by the town of Mesilla on that date.
It was?
It was not.
Correct. And that's what, that is when,
This is not an accurate statement. Because it was approved in 2001.
it was approved in 2001 for this 5 acres, individual partials, right? In 2007 is when they were, now you're getting me confused. Because it says right here, August 2001, it says right here, it gives you all the, when it was, it gives you all the 5 individual parcels. At that time, I guess what I'm trying to show at this, as a timeline, at this 2001, it was 5 individual parcels. And then when Mr. Vejia, I'm not exactly sure when he bought the property or while he had it, he talked to the town of Mesilla and they elected for him to approve if he combines those parcels into one, which is acre parcels, to be able to build a home on. Okay. But as the mayor was mentioning, is one thing I was also mentioning is because now talking about cluster subdivision, Trustee Cadena was mentioning about being able to do all those to preserve conserve our green belt. It's very possible that is why these acres were 1 acre at that one particular time.
That's not what's
It's
stated
something
here.
that I'm gonna have to look at.
It's stated here, October 1st, 2001. The request for a zone change to go into, would adjoin the 3 acre parcel of land so that the applicant can place a single family residence and plant the rest in pecan trees. 3 acre minimum lot size.
Yeah, those are the minutes that I put on the packet. Is that correct?
Yes.
Okay,
So
so
you're saying it's going into 1
No,
acre
no.
lot and into 3 acre.
I-
1 3 acre.
I agree with that. What I'm saying is before it went to 3 acres and there were individual 1 acre parcels where they weren't able to build, it's possible that those 1 acre parcels were 1 acres because they're legal conforming lots because of the subdivision could have done a cluster subdivision at the.
No, sir.
I don't know that.
No
I wasn't here long.
Subdivision should ever have
Okay.
1 acre lots.
That's what I'm
That's what we were avoiding, is that 1 acre lots in Mesilla are very expensive, as part of the argument is, right? And to build, that cluster subdivisions are supposed to be cover 2 things in our comprehensive plan. One, affordable housing, right? Because how many people can afford to buy an acre in Mesilla and build a house on it? Not very many right now. I mean, most of us, most of us way back. So we got our land. I couldn't afford to buy a house in Mesilla right now. I just have it because my great grandparents are here. But my point is that at no time were cluster developments going to have it. The R1 was a zoning, and that was to keep some of that land preserved for just being green, right? So that they wouldn't put 5 houses on an acre, right? One family wouldn't put 5 houses on an acre. But the cluster planning was to take either RA or RF acreage, whatever that may be, because it's not necessarily just 5 acres, right? RF can be 26 acres or 100 acres. I mean, we don't have that much, but it can be a lot of acres. And you would do 9 houses on part of that, and then leave the rest as a green belt, so that you wouldn't have 26 1-acre plots, because that doesn't leave a green zone. That just makes big houses and big lots that use a lot of water. Green belts are different than that. Cluster developments, you get one road in, one line in, one electricity in. You serve people that can afford $150,000 homes instead of $1 million home. I know that because I was there at the original planning for that. So that's what cluster development means. It doesn't mean R1s.
Yeah, I don't think you understood what my comment, but I totally agree with you that in order to conserve, the green belt, there is a cluster subdivision option. Technically, it's about 80% of the property. You're able to build in much smaller lots. It'll save the developer infrastructure, so they don't have to do all the streets. It will save Mesilla, obviously, not being able to have 20 5-acre parcels versus one big one. And generally, what happens, there's something that's put on the remainder of the RF to prevent from any future use of being split and developed. I understand all, but what I'm referring to is before Mr. Vigil rezoned it from 1 acre RF to RA 3 acres, why were those RF 1 acres is my question, right? I haven't been yet able to find the documents on that, but it is possible that those 1 acre parcel, or those 5, not just his, but there are other ones in that community, they could have had that conservation or clustered at that particular time when it was part of their conditions. Therefore, the remainder of the property should have a covenant on. Our records, I'll be honest, our records in the town is very difficult to come up with. So in order for me to kind of make a determination of it's difficult. And I would like to bring that up to y'all for that.
Some of these properties were done in such a way because there were multiple family members. So it's great-grandparents, and then they're dividing it between their kids and things like that. And so things were kind of grandfathered in or specially zoned to provide for a little versatility because of that. But that was way back when, before the encroachment of Las Cruces and all that stuff. Because of course we used to say we're going to town to go to Las Cruces.
Yeah.
It wasn't right. It was a ways. So just to tell you.
Yeah, no, I hear. Well, again, I'm not here, so it's hard for me to make those determinations. But
Right.
I am bringing this up
And
now
I
because
appreciate that the attorney too is being objective, and you're being objective, and Mr. Magallanes is being objective, but in a way, the history is what these things are based on,
Of
right?
course, of course.
And if you don't have that knowledge, you don't have that knowledge, or the reasons that these things happened, right? So, like I said, we understand what the problem is today.
Yeah. Okay, Mr. Mayor, if I may, I have the other comments here from Trustee Cadena and Mayor Pro Tem. We there's more than once that I've heard the comprehensive plan, and we've brought it up, the trustees have brought it up. And yes, the comprehensive plan is when the municipality reaches out to the community to see what the community wants in the future, where they needs to lead, those kinds of things. And there's a lot of mention in a comprehensive plan about agricultural use, and as one of the public comments was stating about remaining a community, slow down growth, those kinds of things. And that's in the comprehensive plan. But again, I like to bring forth that the comprehensive plan is just that. It's a comprehensive plan. And when it's done, that's when the trustees and the governing board and the planning commissioners and all that needs to put some work into it. And off of that comprehensive plan, create rules and regulations and code to implement in our town. But if that is not done, then legally, right, whenever you go to court, whenever there's legal representation or review of this, if it does get appeal to an upper, decision, that is what gets looked at. And that's why a lot of times I fall into a lot of that, because I'm used to reading the legal part of it. If it's not written down in your code, then it's subject to the commissioners or the board of trustees at this particular time. Now, taking it case by case, you gotta give due to the commissioners and the trustees at that particular time, as I am giving you all today, that is your subjective to interpret your code and that is why you're there, right? The codes cannot be written 100% to be clear for everybody's point of view. So treating it case by case is the best way to do it, because their interpretation or code back in the day, a lot of things could have been happening, even as an individual or in the town or throughout times. So always referencing back to, well, that didn't get approved, but we don't know all that information, what's going on. Even it could be subjective, or other information is not relating to you at this particular time. So I want to urge that you do want to listen to what the past were. It's an overall, right? It's kind of like nothing's concrete. I wish it was that easy to just say, yeah, it's done. But that's why there's a commission, and that's why you're subjected to that. So again, I kind of urge you to kind of treat this as a case by case with the information that's given to you at this time. And yes, to answer Mr. Mayor's question or comment about the 80% and the 25, roughly the acres, that there is a possibility that those lots, if they're already intact, 1 acre lots intact it was 1972, but I apologize, March 14, 1972. If those parcels were intact at that particular time, then those lots were a conforming lot. Okay, I just, again, find the records, I take some time to request those kinds of things, but I bring this up because the commission or the board, I apologize, I keep saying commission, I'm used to talking to the commission, but if the board decides, to make a decision today, based on the information that you all have today, it's probably the best thing you can do, other than that.
So were you able to answer my question? I know we're just discussing rezoning it to 1 acre, but I asked if there was a plan. I mean, 10 years or whenever, 2001, we heard that pecan trees were going in, which I'm just asking, what is the plan for that property besides one house? Is there enough for 3 houses?
Yes.
To be legally there?
Yes. Those 3 lots are 1 acre lots. And what was happening, because of the plat that they had created, and they were gonna, I don't know, again, they had it wasn't in particular for the rezone. They just something they had on file, and to prevent, maybe save some money, Mr. Mayor have to redo it all over again. Well, this is the one we have where we want to subdivide it, because of the solar power the RAD in that specific time. 1 acre was a little bit bigger, like 1.12, or another one was 0.8 right next to it. All right. So, but yeah, obviously you can't do that, right? So they were advised, and they completely understand that if they are approved for a rezone for those particular parcels, there could be a condition set to say, yeah, we are going to approve the rezone with the condition that you do exactly what you're saying. It's going to be subdivided in 1 acre parcel and be used for residential use. That could be, but yes, there is plenty of property, 3 acres, not plenty, but enough to meet the requirement of doing so.
To meet the minimum requirement of the current ordinance.
Correct. Yes.
If we rezone it to R1.
Correct. There's no variance or range
Variances or
afterwards.
anything like
Nothing.
that, just in case, because
Yep.
that would not,
Of course.
that would further
Create more. I understand.
create more problems for people that are opposing this in
Correct.
the first place. Okay, so you answered that. Mr. Magallanes, did you have something? I mean, he's kind of bouncing up.
Well, he's going to come at me, right?
Oh, can he say?
Was they're done with me?
Yeah. Good. Any other questions for
Oh,
Mr.
I'm sorry.
Salazar? Or are we set? Did he answer all of your questions?
He answered mine.
Great. All right, Mr. Magallanes, if you would, please. No.
I gotta say, my favorite, I was looking to see when the last cluster development was, and I did this last meeting because I thought it's important to recognize what the town means with that. And the last one that I can recognize was Philippou's on Mesilla Verde. I'm driving west past Avenida Mesilla on Union. Beautiful. I love it. I used to work, I was, while I was going to engineering school, I used to work on his orchards. So I used to irrigate there. So it was really cool to see it transition into a subdivision that is, I wish I could live there. They're 1 acre lots with definitely $1 million homes on them. So if that cluster development is what the model is for our cluster development with affordable housing, we may have missed the mark on that one. But I do agree that this isn't cluster development. And I'll also state, I don't bring up the Los Reyes subdivision much in my conversation because I don't have enough knowledge and I haven't done my due diligence and research with that. Because I would argue that just because they did it doesn't mean we could. I agree with that 100%. So I'm not gonna sit up here and say that because one, I don't know what the terms of that were. I'd read the minutes as well. So you'll never hear me say, well, they did it because I don't play that game. I have a survey from 1982 that was done by a different company that showed our subject 3 acre pieces in 3 1 acre lots, right? So we know that back in the day, there was probably 1 40 acre tract. That was the whole Rayleigh acres. That's what it was. And then at some point they said, hey, we want to give an acre to this sibling, an acre to this sibling, and this sibling. And we used to be able to do that as surveyors by just going out and surveying a piece of property and writing a meets and bounds, a little legal description. You record it, that was it. The county didn't care. Towns of Mesilla, cities of Las Cruces didn't care. But then once we started to develop our development code, they said, wait a minute, you can't do it like that anymore. You have to go through a process. You have to go through a subdivision process to do so. Now, these 1 acre tracts, again, already existed. They were already there. They were already legal. Legal non-conforming because yes, maybe our zoning code said minimum lot size is 3 acres, but we have 3 1 acre tracts. What do we do? There's a piece of land I'm looking at buying in Mesilla. I'm saving, I'm counting my pennies. I'm like, I got this. It is RF. It's gonna call you about it. It's RF, but it's a 2 acre tract. What can I do on it? Will the town let me do anything? I don't think they will, which is probably why they haven't sold it, because the realtor's my friend. The reality is they have to sell it together and then subdivide it or go through a process to merge it to make it conforming, I think, before the town would issue a permit to build. But legally, they can sell a lot. So like legally today, they could sell me one of those pieces of land, but I couldn't do anything with it. And I don't think there's a refund or return policy. So I'd be strapped. And that's a big disconnect between municipalities and our clerk and their title world, right? I deal with that every day and I hate it so much. I'm like, why can't we all just be at closing, right? Like, why can't we all be there? So this did have 3 1 acre pieces. And in 2001, Moise Surveying was hired. I believe, I wasn't there, but I believe it was because Mr. Vigil had purchased the property. And so he's in that predicament where he has 3 1 acre pieces of land and he wants to build a home on one and the town says, no, because you're not conforming. If he had 1 acre of those 3, what would we have done? Would we just say, sorry, buddy, you can't build at home for your family? Maybe. It's a harsh reality, but it could have happened. Luckily, he had the 3. The town made him do was replat it. That's when Rayleigh Acres, the subdivision that we know Rayleigh Acres to be, was established in 2001. That took his 3 lots into 1. I don't know, I guess we could say that's an accommodation to him, but to build him a home for his family. So I don't know if I like thinking that we gave him that accommodation because that's very intense to think that we accommodated him to allow him to build his home, right? But we could say, if anything, yes, the town of Mesilla said, if you want to build a home, you have to take your 3 1 acres and combine it into 1 piece, which is Rayleigh Acres today. In 2007, people did stuff with Rayleigh Acres, but it doesn't concern us. So that's on the other side of the street. So then Rayleigh Acres replat number 2, which means that we're just changing something from number 1, changed everything that's on the other side of Old Farm Road. So they may have, I think there's a 3 acre minimum, there's a 3 acre lot in there. Not sure how they did it. Maybe that was via cluster development. But again, Rayleigh Acres number 2, the 2007 doesn't even concern us. It's everything of us. You could see our lot on that subdivision, but it's not even one of the lots that's shown. So just kind of wanted to make sure that we understood that they were legally 1 acres. Again, maybe legal non-conforming, I'm not denying that. But what was the decision at the time? And rather than at the time say, you know what, because we had 2 options. We could have said, let's rezone the property to 1 acre minimums or replat the property. Replatting the property happened. And it probably could have only happened because he owned all 3 of them. But in 2001, it got replatted. And then again, now we're at the point where we're looking to just almost revert it back to its 3 1-acre pieces. The question was like, I'm trying to answer this or think about the answer to this, and it wasn't a question for us, but why was there a decision change from P&Z from the first go around to the second one, right? I walked away from the first P&Z meeting saying, nobody even talked about zoning. Nobody mentioned zoning. Well, this lot size doesn't work. Well, this isn't there. It felt personal, to be honest. However, I can remove myself from that and say, like, let me look at objectivity and see what the decision was made. But there was no zoning criteria that was making a decision for or determination. It was based on a layout. That layout is just an example. The reality is that, yeah, a board can choose to say, we approve. We approve with conditions, or we deny. And so if there were conditions that were met or requested, the board can motion for those conditions, of course, right? But the Planning and Zoning Board, in their decision the first go around, was basically made on a subdivision procedure. Any of those questions, so if we approached, let's assume that we had received an approval for a zone change back then. If we came to the Planning and Zoning Board with our subdivision at 0.88, at that point they could have said, we don't like this, we don't like this. You have to request a variance or a waiver. But we were making those decisions way preemptively, way too soon. That's why an appeal was produced. And I think this go around, I think the determination was based on zoning criteria, which I think is why we're seeing that there are definitely less factors that we can identify that prohibit us from doing this. I love public comment, so much so that it was really weird because I was asked to write the letter to be mailed out to the residents for the first planning and zoning meeting. That's never something that I should do because I'm biased, rightly so. But I said, you know what, take off my biased hat. I wrote a letter to my community members on behalf of the case, but again, the first time. And I said, we are requesting a zone change. Please participate in public comment, be it for or against this proposal. I did as good of a job as I could to not be biased and sent it out to probably the same group that we sent out the letters to this go around. The reason I say that, I appreciate public comment. I'm willing to talk with anybody for or against this to really understand concern. It helps me understand my community better. Over the last year and a half that we've done this, I've seen, and again, I understand the measures that we take to receive comment. We post it. I've seen it at Shorty's. I know it goes in the paper. It gets mailed out to surrounding neighbors. I've seen the same 4 members of the community. So I understand the importance of it. It doesn't mean it's any less significant, but I stop and say, did we receive any mailed comments back from any members who didn't attend? Did we receive any comments saying we do not want this, however, we cannot be there to voice our concern? I don't know if we have or haven't, and I assumed that we hadn't because he hadn't mentioned it, or else I'm sure he would have. So although I stop and say I do understand that we need to do what is best for the greater good of our community, I don't understand how this isn't, I guess, is the biggest question. Because those 4 people here, I'm glad to hear. I love their voice. I'll talk with them and we can have lunch and hear concerns. But it doesn't, I don't see our community storming in here saying, you're tearing on our green belt. Like I feel that we're getting comments about. Lastly, I always remind myself that our code is our Bible, and it is the closest thing we have to be able to make the best decisions we can as a community. And I feel like second to probably Eddie, I'm the next biggest user of it because I have to say, what does Eddie want? Eddie runs the city, if you ask me, right? Because I say, what does Eddie want? What is, because I have to abide by what the rules of this code say. And of course, we're not going to get that right. Of course, we're not going to get it right on the first try. Of course, we're going to have to modify things as we continue. As events and occurrences happen, we're going to have to say, hey, wait, we have to make some amendments to our code. it's a living document that we're gonna have to address. I think this since day one. I would love to sit there and say, hey, let's have some town hall meetings to really delineate what the green belt means and just find what it is, have those roundtable meetings, invite our community members. So that we can, I think that will help avoid it, because then we have designation to develop against. But until we do that, we're gonna find ourselves in some gray area with this. And I think our best approach is to say, let's use our code in the capacity that we can, and let's use whatever other resources that the town has adopted, which is our comprehensive plan. I'm appreciative that the comment was made about the weight that our code and the development plan, the comprehensive plan should carry, because I agree. But with that, it also states things that I think sometimes are our Achilles heel, or we look at and say, this doesn't fare well for us. But it's the reality of who we are as a community. It also very clearly says the closest thing to green belt is our large lots that are 5 lots. So how do we then know when we're in a green belt and when we're not in a green belt? It should not be subjective. It should not be anecdotal. However, I recognize you guys are having to make a decision based on information that doesn't give you concrete understanding of what that is. But I say, if we take what we know to be true, which is that our comprehensive plan says the town has used greenbelt as large 5-lot or greater zone designations, then I don't think we apply to a greenbelt. I don't think there are any questions necessarily for me. I'd be happy to answer any if anyone has any. If not, I just wanted to address those comments. With the other comment I have here, I think I mentioned this, just want to retouch if I didn't. This would not be the 3rd time that the Vigils are coming for an accommodation from this board or from the town of Mesilla. The first time I think was in fact, this is what we have to do to build a home for our family. I don't really think that's much of an accommodation. And then there hasn't been any request except this to say, can we rezone it? And luckily, this is a bureaucracy, our democratic system, and that we can turn around and say, by right and by code, we are allowed to turn around and request this if we can. And we have the avenues to say yes, no, maybe, and they're just exercising that at this point. Any questions?
No.
Thank you.
I mean, so your board action form, did you see that rezone application? I mean, it just has RF to RA. It says it was done in 2011. What's that about? I mean, I think it's wrong. I just think the board action form is wrong. Look at it.
I have it right here.
Well, this is as of 8/19/2024, which I know it's not today, but at some point.
Okay. What's the typical use?
I mean, so, it's just that we already have, see what it says? Which isn't, okay, it wasn't rezoned. There's no way it could have been rezoned from RF to RA in 2011, or it would blow the whole timeline that we've been talking to about since 2007, right?
I don't quite, I know it was switched from 1 acre lots
RF is
to
5
RF to
acre.
RA, right?
Right. RF to RA, it says here, 2011.
Uh-huh.
It was never RF. You're telling me it was R1.
It was never RF?
No. Not in 2011. If in 2007 it was R1, nobody changed it from R1 to RF to RA.
That's not on my record. I my records show that it was an RF,
I'm just saying,
1 acre
I mean,
parcels in RF.
So,
I mean, minutes show 2001.
I know.
So that RF to RA.
Correct.
Then why does that say?
This
RF to,
2011?
this says 11, but you're telling us it was never RF. It was always R1. I mean, it was R1. And you asked to RA because RA is a 3 acre.
So I think that there's, and maybe this, I mean, I don't want there to be confusion between what we're saying is zone designation versus what the lots are. Because the lots were 1 acre lots when it was not zoned R1. Therefore, they had to replat it to meet the requirement, which was RA for the 3 acre. So
you replatted it, I mean.
In
it
2001.
went from RF, it did go from RF.
I'm not saying that it went from RF to RA. I'm saying that there were 3 1 acre lots prior to 2001, and they could not build their house because the code said this is a 3-acre zone and these are only 1-acre lots. And again, that's what I'm saying. That exists today. Well, I think we're confusing zone designation and the number of lots and replat.
Well, it's not, it's confused
Sure.
because that's what it says on the board action form. So it's not a.
And I don't have a board action. Yeah.
Or anything. And when you say R1, you're making the assumption that it's, you say they're 1-acre plots, that's different than R1.
I'm not saying R1. I've never said R1. What I'm stating is RA. So as 1-acre lots, we can have 1-acre lots in an RF. Would we agree with that? Not conformingly, but would we agree generally that there can exist non-conforming lots? Yeah, and that's a situation that we had.
That's in 11. So can you give us a correct timeline again?
2001.
I mean, Mr. Vihil, when did you first, maybe he can explain it.
It's right here.
It's right, it says October 1st, October,
I
so,
think it's a typo.
so there's 2 or 3 different things. That's my problem with it.
It's
Not-
right here.
Well, it says a different thing right here in the same.
board action, I
document.
think it's a typo.
So we shouldn't have controversial information on the same packet.
Yeah.
Trustee, if I can give you a brief history
Yeah, if
on the
you could
time.
just give me the timeline. When
Yes,
did
ma'am.
you buy the property, Mr.?
This is back in 2000, okay, or 2001. I mean, it's been some time. They were all 3 1-acre lots.
Okay,
That's how the county had them platted and everything. I came before the trustees, the plan zoning and everything. I went through the whole process. The town, I had legal representation at the time. At that time, the trustees went into a closed session, hearings, whatever. They came back and said this, and this is not me saying it.
I believe you.
We will allow you, the town, to build a house if you have it replatted from 3 1-acre lots to 1 whole lot of 3 acres. But
And what year was that, like 2001?
that was in 2001, I believe.
Okay,
October 1st, 2001.
I believe. And that was called the Rady Acres. There were 3 different
and
lots.
so that is the only change that you have requested.
That was the
until
only
now.
change, yes.
Okay, and what you did was you accommodated the request, the accommodation that said you need to replat to RA, which requires a minimum of 3 acres.
And madam, at the time, I was asking to have 3 lots, 3 acre, like how I bought them. You know what I mean? So I was caught in a bind, how I bought them. So I went before the town of Mesilla. And they said, no, this is not gonna happen, we're gonna have you replat, and that's the only way we're gonna allow you. That's what came back out of the session. And I said, at the time I said, I wanted to build. I was in a bind and I needed to get going because I'd already spent some money on that. See what I mean? And so I did it. You know what I mean?
But, I mean, just the big picture, the timeline is you bought property, they were called 1-acre plots, they weren't zoned R1. They asked you to replat, whoever was on the commission, on the board of trustees at that time, and you did it.
Yes.
So now in 2024, you are coming to us and asking us to rezone it to R1, correct?
Yes, ma'am.
That's it.
Yes, ma'am.
So everything else, all the dates in here, 2007, 2000.
And I've not
You ever applied for zoning? change?
And I've not been here 3 times. I've not been accommodated 3 times.
Okay,
No.
I think, again, I think with all the back and forth stuff that we've been through with your particular piece of land, for some reason, we have like 4 different dates right
Yeah.
now in our board packet,
Yeah.
which is not your fault. And which makes it we're having to make a decision that a lot of residents don't agree with,
Yeah.
right? And they've made themselves known, and not one person that says things that,
And you know, Madam Cadena, the minutes back then reflect all that. I did have legal representation and everything, and that's when the Board of Trustees went behind in a closed session. And they came back and said, okay, we have this one option. We will allow you to build a house. That's what I want to build, but you're gonna have to replat it. We didn't talk about rezoning, about RF and all this. I mean, that was all that zoning was left out. It said, we'll let you do it, but you're gonna have to replat it.
to a 3-acre plot.
Yeah.
Okay.
And the minutes will reflect that.
Okay, I know, but
Yes.
I mean, for me, I mean, it should, this is the packet that we just received today. During the hearing, a lot of it that we have looked at many times that, you know, I have to recuse myself. I mean, it just goes on and on. So I just needed to get down to the basics of what was actually happening here, because I don't know if it's a typo or 10 typos or what is going on, but I got it. Thank you so much. I don't know if anybody else has anything.
Trustees, literally scheduled meeting time, but we do have 2 more hearing items to hear. We'll go ahead and move forward with continuing our public hearing since we have our public in is revision of ordinance 9.10.170 concerning fireworks. I will have Mr. Fire Marshal or Fire Chief, sorry. We'll discuss a little bit of the changes. So we'll have you come up. If there are members of the public that are here to speak on this, whether in favor or against, please stand if you would. And if you would raise your right hand, and Gloria will. Thank you very much. Mr. Chief, let's just come up real quick and just to answer right off the bat. So this is, and I'll kind of give the background as well on this. This is discussed in a recent work session and concerning the fireworks ordinance part. The changes that were made on here specifically were those that were noted by the attorney. Were the last one, which would be adding section H. For extreme and severe drought conditions, restrictions pursuant with NMSA 1978, Section 60-2C -8(1). The town is authorized to impose restrictions on the sale and use of fireworks within its jurisdiction when the governing body determines there is an extreme or severe drought conditions there was, and this was based upon feedback as well as information provided by applicants as well as by the fire marshal. And section F, where a monthly fee of $750, which may be paid annually, which equates to that $9,000 that was suggested by members of the public then. And so that's what we're having there as changes. Is there anything else noted, Mr. Chief?
No, looking at the fees, they basically equate to roughly what the smaller vendors were paying for the couple of months that they were open. So if they're paying that monthly fee, it's not becoming an undue burden on them or anybody else. This should equate to what their normal permit fees were. Meanwhile, we're not chasing permit fees. We're not having to track all this down. It's just a fee that gets paid ahead of time. We call it a hazardous materials fee, however you want to do it. And then the vendors can pass that along to the final purchaser.
Thank you.
I think that's it.
Simple and easy, right? So we'll move forward and move into public specific comments. So those, if there are members, let's start with in favor. Please come kind of there in between. I mean, there's only 2 of you that said you were going to talk on it. So
I apologize.
Up and give your comments.
Mayor, trustees, I apologize if you can't hear me. I don't want anybody sick.
You would just state your name for the record, please.
Jimmy Nevadas, Senior.
And Mr. Jimmy Nevadas, you have been sworn under oath.
Yes, sir. Yes, Mayor.
Thank you.
I've got a few corrections I'd like to propose. The 4th. Our display doesn't even start till 9:30. which doesn't give anybody time to shoot fireworks if you're gonna prohibit that at 10 p.m. So that makes it very difficult for the people in the town to get any fireworks after the display by moving an hour. So I propose it should be left at 11 p.m., not changed. They're spending all that money coming here and eating dinner. You know, a lot of these people do come here and eat dinner and watch display, then light their fireworks. So I think that's an undue burden on them to try to light their fireworks while the display is still going on. The display doesn't even end sometimes till 10:15. That's the first change. The other change, which the chief mentioned, and I'm sorry, I'm going back. I did have a little bit of concern too, going down a little further to section D penalty. And this would have to go to the city marshal, whether he wants that left written as it is, where it's saying at the discretion. I'm not sure that we want anything enforced at anybody's discretion. I think it should be black and white, but again, that would be a question for the city fire marshal. But discretion leaves, you know, some gray areas, which I don't think you want to have as far as enforcement goes. The last change that I would like to pose is this monthly fee. I don't believe that that's fair, and there's no such thing as a smaller vendor. That should be a yearly fee, charged monthly, regardless of whether you set up once or not. 90% of sales are July 1st to the 4th. So it doesn't matter if you only open for 4 days, which we know who we're talking about, Gary Tyndall. He only opens on July 1st, and that's because he tries to avoid the state inspector and always opens late. And so that's rewarding him by only charging him a $750 fee, and he gets to make 90% of his sales on that one time. We're going to be paying the $9,000 and carrying the city over. We also have now, I'm sorry, this is hard for me to, with this cold. You know, now we have 4 full-time employees. You know, we pay taxes, everything else. So it's a burden to us. We're not really open to make profit in the rest of the year. They're more of a convenience for us. So it's not like we're making thousands of dollars and making that. But I can tell you that we probably bring in 3 or 4 additional people into Mesilla every week from our billboards and our signs that stop. They do buy fireworks, they're tourists, but I guarantee you they shop around Mesilla and spend that extra additional money. So we're contributing year-round to Mesilla, not just with fireworks, but getting the tourists here. So it's really unfair if this is going to be just charged on a monthly basis and the other vendors not going to be paying the same amount. There should be a yearly fee, and it should be, I'm going back to my notes here, I'm sorry. At the very last, it says can be paid annually. It should say it can be prepaid, so that maybe we can pay 6 months at a time in 6-month increments, not chosen to do, you know, 1 month or annually right now, the way it's written. And it should be written prepaid, and it should be written, as I said before, for 1 year fee totaling $9,000 for any vendor. I stand for any questions, Mayor, trustees. Thank you.
Thank you, Mr. Nevadas. Further public comment? Is there any other member of the public that would like to speak on this ordinance? Mr. Chief, if you would, please address the questions and the concerns.
Yes, sir, and board. The legal process that provides protections for those weird events where you have some, like you have a choice and a chance to make a difference when something is gray area in there. So once it gets into the hands of the court, then it starts becoming, hey, this is what the law says, and we start following that. So I do think the discretion, well, I don't think we can enforce non-discretion. The monetary cost, we've discussed it, and it's really up to the board on what they feel is fair. I understand where Mr. Navarez is coming from, and I also understand that, you know, at one point he was a seasonal vendor here. So there is a difference. And do we try and come up with some middle ground in here? I don't know. But there is a difference between the person who's only open for 2 months out of the year versus the business that's open 12 months out of the year. It's the same thing with our seasonal vendors that come and sell during the plaza events. They're not paying the full yearly fees that a regular business, a brick and mortar business is open 24 hours a day or whatever. Well, we don't have that, but you know what I mean? All year round, they're paying different fees. So that's all I have to say on either one of those. And I stand for any questions from anybody.
Members of the board, questions or comments? Trustee Johnson Bjork.
And maybe I missed it, but I know that one of the reasons for, and probably the primary reason for changing this was to accommodate what was missing from the state requirement that we talked about at the work session. I know we had talked about the permits, but there was something else that was, or was that a different ordinance?
I think that was a different ordinance.
Was it a different one?
The whole thing we were doing here is we've been chasing paper, and it's not, yeah, and that's what we're trying to do is just eliminate that and make things easier.
So sorry,
Oh, no.
trustee.
Go ahead.
No. Trustee Kalena, any?
Well, I think what we worked out in the work session and what the proposal is something that works better for the town of Mesilla, definitely. But, you know, I mean, if there's a compromise.
I don't think they can hear you out here, ma'am.
I didn't see any changes that needed to happen. I mean, I don't know if we want to, if there's a compromise to be made with the monthly versus 2 months out of the year. I don't know. But I think that this ordinance is a definite improvement.
Oh, I'm sorry, I do concur with Mr. Nevadas about the time change. And I think that was a very valid point.
And I'm okay with that too. We're out anyway, and that one day a year is a decent compromise for everybody. I think everybody's aware that that's gonna, we do get complaints that we allow fireworks, but that's every year. Yes.
We're going to get complaints. Yeah, I agree with that too.
Mayor Pro Tem.
Sorry. What is the different costs between year round and the one-time stand?
So the way the ordinance is written is that the year-round sale, well, basically you're paying, if you're open for any portion of a month, you're paying that monthly fee. So the year-round sale would pay $750 a month times 12, which comes to $9,000. The other business that's only open 2 months out of the year would pay $1,500.
Okay. So on that note, I understand how we have brick and mortars versus what we're selling on the plaza, but fireworks is a very unique sales category. I sold fireworks with my parents for 13 years, so I know. And I think that you do make almost 100% of your sales on those two events during that year. Because if not, then it wouldn't be worth it for my parents to be out there for 8 days. So I think that adjustment needs to be a flat fee for everybody. Again, the situation is unique to this vending. If it was as far as like the plaza and stuff, that's a little more intricate. That's a little different. But this particular sales of goods is definitely made 100% on 2 years of the year, 2 times a year. So I think it'd be best if we change that back to a flat fee for everybody.
Just something that can be discussed during the regular meeting as well.
Mhm.
This is only directed questions for.
Oh, sorry. I
No, no,
apologize.
You're fine. Just clarification. Any other questions, trustees, or comments? One comment that I do want to make as well is on section D, as it was mentioned for penalty. 8D, I'm sorry, for the penalty, that the verbiage that's in that was that as it was changed, was that was recommended by the legal team when we were changing that. So having that where it was at the discretion of law enforcement for confiscation by the specifics that are happening there rather than as it was or by specifics in there. So it just kind of changes that verbiage in there to make it the law enforcement's discretion per se. And so just clarification on that for advice. And I don't have any other questions or comments. Trustees, thank you, Fire Chief. Next, hearing item number 3 is revision of ordinance 18.33.030 for Historic Preservation Authority. If there, Eddie, I'll be having you on this one. And if there are members of the public that are speaking either for or against this, please stand. And there are no members of the public that will be sworn in. Mr. Salazar, if you'll give the background.
Hi, good evening. Yeah, this ordinance proposed to amend really was started when last year, maybe it was this year, but I believe it did start last year, when the Cultural Affairs and CID started working on the Taylor Museum. There was a miscommunication between the state agency and the town of Mesilla, and I was part of that, and efforts to be on the same page. I met with Deputy Secretary, I believe she is, Garcia Griego from State Cultural Affairs, and along with some constituents that she brought along with her. And basically, she was the one really that brought up this section. And our code currently adopts a section in our code and our historic preservation 18.33.030 is under authority. And our current code adopts New Mexico State Statute 3-22-1 through 322-5. Kind of odd because there is a sixth section in there that was not adopted by the Mesilla Time Code, and that's the one that I'm proposing today to adopt. And basically, you can mention right there, if you look at behind, the board action form, there is sections 3.21, 2.2-1, and it just kind of 2, and then it goes all the way down to section 3-22-6. And but this is, I'm going to read it straight out of it because I think it's pretty much self-explanatory. It's applicability to construction or renovation of state buildings. Recognizing the fragility of the state's historic heritage, the purpose of this section is to establish a procedure under which the state and its municipalities and counties will commit to collaborate in good faith and work jointly to preserve and protect the historic districts of New Mexico. In a nutshell, that's pretty, and it kind of goes down to explain how to do so, right? Again, there was a miscommunication, give you a little brief history on that. CID, along with building inspector, some construction started work, and there was no, Mesilla was not advised of that. There were no permits issued. We didn't know anything. So again, this is to kind of prevent, to stop from that from happening, hopefully. And including this in our code, we can use that for our best interest for our community, especially historic landmarks that we have. And I stand by for any questions. Again, these are for state-funded buildings that Cultural Affairs and any other agency are involved in, not private properties.
Trustees, any questions for Mr. Salazar?
No, but that's right. This is the one that was, I was alluding to earlier.
No, this
Thank
is what was left out, but.
All right. Seeing as there are no questions, thank you, Mr. Salazar. And so this does conclude our public hearing for today. Hearing cases, hearing number 1, rezone case 061870 for 2750 Old Farm Road. Hearing number 2, revision of 9.10.170 for fireworks. Revision, and then number 3, a revision of ordinance 18.33.030 for Historic Preservation Authority. The time is now 6:46 and the public hearing is now closed. I will call, unless there is objection, for a 5-minute recess before we start our regularly scheduled meeting here at 6:51. Just to give a break for restroom for anybody that might need it. Or to stand up. I did. And put some water as well. Yeah, definitely. So that's like. That's what. I was thinking more for blood sugar because I know the longer meetings, sometimes you need a cookie or something. But yes, that always happens. Is that acceptable?
For the 2000, I think it's 2000. I don't think
Yeah,
it's.
because the minutes.
Yeah, it wasn't even RF to RA. That's the other problem.
Yeah.
That was then.
Gotcha.
So it was, because when you look at the original document. When it's so.
Well, I think this is gonna make everybody. Yeah, but they don't fill out that, they don't have to go here. Well, that's all the poster for the, you know, for the poster. Well, they
No big deal. Yeah. And it's true, the. It's just that. It's a law-abiding citizen.
This is my wife. I guess they hit after their time. I'm the only one that knows this kid. I didn't do this. Once you
It just has like a hollow sound. It's the trustee. It's a lot of paperwork going all the way across this desk.
Right behind, you can't get to it.
It feels good. I need to move my little plant out of my office. This is my office.
Sitting on a park bench. Right up on her.
But I know we can facilitate
So last.
Tries to turn the heat around on me all the time. All right, everybody, here we go. Today is Tuesday, October 5th, 2024. The time is now 6:54 in the evening. We are here for the regularly scheduled Board of Trustees meeting at the Mesilla Town Hall. The first item on the agenda is the Pledge of Allegiance. If you'll please stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next order of business is roll call and determination of a quorum. Gloria, if you would, please. Present.
Present.
Present. Here.
Great, thank you. Next item on the agenda is changes to the agenda and approval. I can have a motion, please.
So moved.
Second.
And if there is no objection or discussion, the agenda will be approved as it's been noted. Thank you for approving the agenda as it has been noted. Next item on the agenda is approval of the consent agenda, which includes the BOT minutes for the September 9th, 2024 meeting.
So moved.
Second.
Who made the motion? Sorry. Okay.
I did.
Motion by Mayor Pro Tem Merrick, seconded by Trustee Cadena. And there again, if there is no objection or discussion, the consent agenda that includes the BOT minutes for 9/9/24 will be approved. There's no discussion or objection. So the approval of the consent agenda that includes the BOT minutes for 9/9/24 has been approved. Next item on the agenda is public input on cases. This is where we give the public the opportunity to come up to the podium and give input on the cases that are under action and consideration this evening. So if anybody has input on the cases to be heard, please step to the podium and state your name for the record. Okay, seeing as there is no public input, we'll move up into our first action item for consideration under new business is approval of rezone case 061870. This was from our public hearing, 2750 Old Farm Road by Enrique Vigil, Melanie Altuna Vigil, requesting to rezone their property from residential agriculture to 3 single-family residential zone, R1.
Second.
It's been moved by Mayor Pro Tem Merrick, seconded by Trustee Cadena. We will open it up for discussion. If there is any.
No, I just make a comment that Mr. Vigil is absolutely correct. He's only rezoned it twice. So, or this will be the second. So my apologies. I was thinking R1 to RF to RA.
One thing that I do want to note on my side is that to just remember that this is the case that's in front of you is specifically for rezoning. So this is changing the zone specifically. This is not actually dividing the property. That would actually be a separate case, a separate everything from is that if you do vote against the approval of this, just because this was voted on by the Planning and Zoning Commission and passed by the Planning and Zoning Commission, if you would state the reasons why you are not voting for this specific case. And if there are no other questions, we will move forward. Any other questions or comments? This is approval of rezone case. Well, one thing that I also want to state on this is that this, per the ordinance, this case does require 2/3 vote of the governing body. So I will be participating in the vote this evening. So we do have approval of rezone case 061870, motion by Mayor Pro Tem Merrick, seconded by Trustee Cadena. Gloria, if you would, please.
Yes.
Trustee Johnson Burek?
I appreciate and understand certainly the concerns as why the Vigils are here, but I will be voting no. And my reason is in reading the resolution, just some of the inconsistencies with the dates, and I don't know the parcel, and then could be misled that, you know, February 24th, 2007 was when it was approved by the town of Mesilla, and it wasn't. And I don't see enough, strong enough, the yeses on this resolution to support the rezone interest of Mesilla as a whole. And I don't feel that it is. Thank you.
Mayor Pro Tem Merrick?
Yes.
Mayor Nunn?
Yes.
Mayor, the roll call is 3 yeses and 1 no.
The rezone, because this case does require a 2/3 vote of the full board, unfortunately, that would require 4 members to vote in favor. So this does not pass, unfortunately. So I do apologize about that. You do have Just to note, you do have the right to appeal this with the next level up within district court. Thank you. Next item on the agenda is revision of ordinance 9.10.170. This is again from our public hearing concerning the fireworks ordinance. Can I have-
So moved.
Second.
Moved by Mayor Pro Tem Merrick, seconded by Trustee Cadena. We'll open it.
We're able to make amendments.
Yeah, we can do amendment.
Creation of year-round sellers and seasonal sellers for the fee to be a flat fee for everybody.
Just looking at that flat fee of the 750 a month. So that would be 9,000 a year flat fee.
Yes.
Is that your proposal? Sorry.
Yes, sir.
And on this amendment, does trustee want to add the 11 p.m.?
Yes, I will also add that amendment being prohibited after 10 p.m. to it being prohibited after 11 p.m.
Okay. Is there any other
I think that was-
proposed amendments, Mayor Pro Tem?
Mm-mm.
Floor to amend section 7 to state the time of 11 p.m. In order to accommodate the display for that. And then section F, which would change the monthly fee to not be a monthly fee, to be a flat rate of 9,000 a year. So motion on the floor by Mayor Clerk.
Long meeting.
Is there any other discussion on the proposed amendment? Seeing as there is none, Gloria, roll call vote for the amendment, please.
Mayor Pro Tem Merrick,
Yes.
Cadena,
Yes.
Trustee Johnson Burek. Mayor,
I don't, oh, yes, I do vote on this. Yes, I do. That says 2/3 vote. Yes.
Mayor, the roll call is for you.
Great, thank you. See, someone's not used to 2/3 vote. So the amendment, as it has been proposed, does pass. Next, are there any other suggested amendments? We will, there, go Merrick, second by Trustee Cadena, for approval of the ordinance as it has been suggested to be amended. That's the vote.
Trustee Johnson Burek,
Yes.
Cadena,
Yes.
Mayor Pro Tem Merrick.
Yes.
Yes.
Mayor, the roll call is for you.
Great. Thank you very much for the approval for the revision of the fireworks ordinance 9.10.170. Next item on the agenda is approval of the revision of ordinance 18.33.030. This again is from our public hearing. If I can have a motion. Please.
So moved?
Second. Sorry.
Moved by Trustee Johnson Burek, seconded by Mayor Pro Tem Merrick. We will open it up for discussion. There is any?
Nope.
Seeing as there is none, Gloria, roll call vote if you would, please.
Trustee Cadena,
Yes.
Trustee Johnson Burek,
Yes.
Mayor Hernandez,
Yes.
Mayor Pro Tem Merrick.
Yes.
Mayor, the roll call is for you.
Okay, thank you very much for the approval of the revision for ordinance 18.33.030 concerning the Historic Preservation Authority. Next item on the agenda is an approval of an appeal for PH. So we do have an appeal this evening, PHC cases 061823 for 2450 Calle de Principal, submitted by Felix Armijo, requesting approval to construct a 30 by 36 foot structure on the property for the purpose of operating two short-term rental businesses in the historic commercial zone.
So moved?
Second.
Moved by Trustee Johnson Burek, seconded by Trustee Cadena.
Mr. Mayor, I'll be recusing myself from this vote.
Okay, thank you, Mayor Pro Tem Merrick, for noting that you will be recusing yourself from this. What I would ask is if you could leave the room for the recusal, and we'll call you back when we are concluded.
Mr. Mayor, I didn't see anything in the packet.
And that's because of the appeal, so Eddie's hands up.
Oh, okay. I was jumping the gun. I was like, yeah. I was like waiting. I wasn't patient enough for you, Eddie. Sorry.
Thank you. Eddie, thank you. But one thing that I do want to ask before, just because I've had a little bit of that, is before we move forward, is was our determination made by the Planning and Zoning Commission for this specific case?
Yes, this case was heard in November 16th, 2024, and the motion to approve was made. There was a commissioner that was absent, and the motion to approve, the vote was 2-2. It didn't pass.
So it died because of a lack of vote, basically.
Pretty much, yeah.
Before we move forward, trustees, I would actually put a motion on the floor, send this back to Planning and Zoning to be reheard by Planning and Zoning in order to have a full vote of the board, so that we do have a measure that actually carries either in the or against, and not having something that comes before us as an appeal that died because of a lack of vote.
So moved.
Yeah, I made the motion.
Oh, second.
Okay, so thank you
Thank you.
on that.
Isn't confused.
I know. Nakadana did. I made the motion. Is there a discussion on sending it back to Planning and Zoning?
So I guess I know that the concern when it was brought to us was about the historicalness of the building that was there in existence. And then I know we had information in one of the meetings following that, in which there actually was documentation reflecting that the, excuse me, the information we received from the Historical Society regarding buildings and, you know, if they were still actually structures, and that there wasn't an issue with this historical site. And then it was pulled from that board meeting. So I see that it was denied because of let's see, denied based upon no zoning permit previously issued for filling in the basement. So do we need to have a permit for that?
Are we in discussion, Mayor, or are we doing a motion?
Well, I mean, as long as it pertains to the
Okay,
motion.
if I may. Okay, I just want to make sure. In order to fill a hole in Autonomous town code, there's no permit. It's considered a landscaping. You're covering up a hole, and our code doesn't dictate. Now, maybe CID has those requirements, but the town code does not regulate any specifics of, do you need a permit to bury a hole, right? Yeah, so it's not, there's no unnecessary permit needed for filling a hole in a sense.
So the site was never, and I don't know if this is appropriate or we just send it back. And then
Well, that's what I'm asking.
I think that for this discussion should be regarding sending it back to specifically to Planning and Zoning. And as I mentioned, this was a 2-2 vote, and giving the applicant the due process, because we should never have something that, in personal opinion, that comes from the Planning and Zoning Commission that dies because of us having a split vote. We should need to give our applicants due process, and they should be able to have that. So sending it back to the Planning and Zoning Commission, because we were short a commissioner that day, so we did not have a member of our 5-member board, but that way we do ensure that we do get a full vote on this specifically and not have something that is so not have that.
Left hanging.
Yeah, left hanging, exactly.
But, and obviously, if it would have been 3-1, this wouldn't have been an issue.
Well, depending on which way, it would have been 3-1. We don't know that because it needs. My
No,
suggestion
for
is-
this, we wouldn't be sending it back. If we
Correct.
had
Yeah,
that it wasn't a tie, it wouldn't be an issue.
correct. That way we have either a vote for or against,
Right. See what you mean.
right?
That's what I was, yeah.
So if it were against a true appeal rather than
Right.
something that's arbitrary. Is there
Okay, so
any other
you want to
discussion?
send it back? Okay. All right.
Any other discussion on the motion on the floor to send it back to planning and zoning to be reviewed and revisited for a full vote? Thing is, there is none. Gloria, if you would, please.
Trustee Johnson Burek.
Yes.
Trustee Cadena. Yes. Mayor Pro Tem Merrick. Mayor Hernandez.
Yes.
Roll call, three yes.
All right. This is a unique one per se because appeals do require the 2/3 vote, but with one member still or not present as well as one member not present, it is that. But I do believe and legal is here as well, so they can also provide further discretion if necessary. But I do think that given the circumstances, we should be fine in sending it back for process.
Board mayor, yes. Correct. As far as
Great. So that is the motion on the floor to for case PNZHA C case 061-823-2450. The Paul Planning and Zoning Commission for a full vote by the full board. All right, and then let's get Adriana. Okay. Thank you, Mayor Pro Tem. Next item on the agenda is for approval. Item E, approval for Planning and Zoning Commissioner appointment. This is an open position. If I can have a motion on the floor, please.
So moved.
Second.
Motion by Mayor Pro Tem Merrick, seconded by Trustee Johnson Burek. And we'll open it up for discussion. This request for appointment is for clarification on a lot of things because we got a lot of moving parts on this appointment per se. We did receive a letter of resignation from Mr. Davey Salas, who served as the vice chair for this because he has not been present for the meetings or for part of the year and doesn't foreseeably know when he might be back in the area specifically. So he did resign from the board. So that did open up a seat on the 5-member board as it is. We did have one member that was acting as an alternate, and that was Miss Martha Mulvihill. And so I asked Miss Mulvihill if she wanted to step into the open position, to which she respectfully declined and said that she wanted to stay as an alternate. So we have an open position on the board. I did receive an application for this or a letter of interest, I'm sorry, from Miss Christina Alba. that lives at 2460 Calle de Santiago. And she writes here, and I'll read to you because I didn't include it in the packet, which I apologize. I'm writing to express my interest in serving on the Planning and Zoning Committee for the town of Mesilla with a genuine interest in the future growth and sustainability of our beautiful community. I believe I would make a valuable contribution as a member. My background in real estate has given insight into how thoughtful zoning and planning decisions can positively impact both business and residents. I have a deep appreciation for balancing the needs of economic growth with environmental sustainability and preserving character of our neighborhoods. Through my work with Jackson's Acoma in Albuquerque during the riots in 2021, I have developed skills in negotiation, problem solving, communication, working collaboratively and quickly to preserve our downtown neighborhoods and small businesses. I would like to express my gratitude for the chance to discuss how I can contribute to the crucial work of the Zoning and Planning and Zoning Commission in our beloved community. And that was the letter of interest, Christina Alba. Is there any questions or comments? Seeing as there is none, Gloria, roll call vote, if you would, please.
Mayor Pro Tem Merrick,
Yes.
Trustee Cadena,
Yes.
Trustee Johnson Burr,
Yes.
Mayor Lopez, 3 yes.
Thank you very much for that approval of our newest Planning and Zoning Commissioner, Ms. Christina Alba. Next item on our agenda is approval of our state fire MOU.
So moved.
Second.
Motion by Trustee Johnson Burr, sorry. Seconded by Mayor Pro Tem Merrick. I will open it up for discussion. And if any. No? Seeing as there is none, I'll, Gloria, roll call vote, please.
Trustee Cadena,
Yes.
Trustee Johnson Burr,
Yes.
Mayor Pro Tem.
Yes.
Saldana.
Yes.
I'm sorry, I'm writing and I'm trying.
It's okay.
The roll call is 3 yeses.
Great. Thank you very much for the approval of that state fire memorandum of understanding. Next, we have our public input. This is where the public is invited to address the board on any other subjects that you may deem unnecessary. So if there is any other public input, please come to the podium and state your name for the record.
Good evening, Board. My name is Catherine Wakacha. I live at 2134 Calle de Principal, and I'm just here to announce an event on Friday evening in support of the nonprofit Carencia de Mi Mesilla, and we are holding a wine tasting at Heart of the Desert, raising money again for the wonderful Adobe interns are doing. They're working on the property, the Butler property, what we all know is that right now. All the interns this time are females, so that's interesting. They're going to be giving a presentation that evening. It's from 5:30 to 8 at Heart of the Desert there at the Mercado. So I'll pass out, and tickets are going fast. We have a limit of how many we can have. So we're hoping the community might join us.
Thank you, Ms. Walkinshaw. Is there any other public comment? Okay. Seeing as there is no other public comment, we'll move on to our next item on the agenda, which is closed executive session for discussion of limited personnel matters pursuant to NMSA 1978, Section 10-15-1, H2 for the Marshals Department.
So moved.
Second.
Motion on the floor by Mayor Pro Tem Merrick, seconded by Trustee Cadena. And if there is no objection or discussion, we will be leaving executive or the regularly scheduled meeting to go into closed executive session. And the time is now 7:21. We are entering into executive closed session.
Oh, you're fine.
You're on my agenda, don't worry.
All the fireworks. So, but, yeah, more like. My son is saying that it's done by. He only said it was.
First one back, I'm like,
But
I
they
have practice.
always make it a really deal. That guy. He does what he might, but he makes. You know what, they make so much. They don't have state. They all lost certain rights.
Oh, the big one. Feeling better?
Oh.
Yeah, it's gonna leave before I can announce it. So just the interview process a little easier now. Zoning commission. A lot of interest in supporting that you do.
I know. So you just have to.
Good job. Fire.
That's like, who's got?
Closed session.
I think it's good. It's just, oh. Mine could stay like down soon. Because I think we're about.
34.
Yeah, and we have reservations. Well, they need to buy their tickets. Yes, they will, because I had through 2 or 4 reservations. So we have $10, one other couple.
You know,
Yeah, we'll tell them to buy their tickets. So I mean, because if someone else gets in by that.
I'm just saying, we're gonna need to take note how much.
But we wait till it's.
I get notification. 15 minutes ago, it's 34. So I see 40 on it, the check box will leave.
Yeah, okay, I was worried you were gonna shut it down early and save it.
Well, there are a couple of tickets that they need to. They're in there. So, but I'm gonna send them one more warning. Yeah.
Grace making me.
They are now.
I have a paper and then she sent me text messages.
I'm just saying, if you get electronic, you don't have to retype.
We're not typing it.
Sorry.
They're on a sticker.
Calligraphy.
Yeah, well, that's why they have Eric tickets. He's got easy to just.
I'm guessing there's no after.
Well, we're thinking about it. It's Tuesday night.
They're in the same chair. Yeah, we could.
When you need to tell Trina if she wanted to.
Another 6 o'clock in the morning day.
Yeah, go down there.
Okay.
From 6 to 9.
We'll do our duty.
No, we're there with the.
was like midnight.
So
Yeah.
somebody's gonna have to walk.
That was us, and it's-
You walk? Yeah, we both walk. Well, I would walk tonight. I could miss it here. I walked down there the other night.
County, we had. All I got on the order, you.
I don't get
Right in the back to pick up.
I've always wanted to do that.
But
I've always
counties,
wanted to
that's
ride
your
back.
Good lady.
disperse them out. And on their second set of related crews, I went to them and I said, oh, I don't know.
So, yeah, just wait until.
This is it.
We're going over there.
We're at that point now that I don't think you need to. stay.
Oh, right.
You're gonna have to go.
Yeah, I learned. Yeah, we should.
I don't know the woman.
So just. One more constellation,
She said,
is
how
that
many
there?
personal storage? We need people. Yeah, so, that's what's happening. Yeah, but you're doing
Do you think there's a meeting tomorrow?
Well,
Still.
I'll send out
Try, I know, but I mean, I wish there was someone. A was a business person that got us to run and I couldn't.
I think what happened was. Right.
was
So
the
that's
person
all.
who's
And I-
visited,
I-
stayed.
And then Paul said,
Explain why they
those
were
places
there,
you
and that's
want to
what
stay.
we did.
And I didn't have the answer, though, that's why I answered today.
We need someone like that.
Yeah.
So
So
these
you
are the
still have to do
changes.
it, because Gina thinks you're working on it too, but again, it's response, so.
And I don't know.
Those black holes, right? We're just being screwed up. I say we have to do it.
I mean, but also some, you know what I mean? It's just complications like that, and I don't I mean, I can talk about. But I'm not. And I'm not.
Yeah. All right, the time is now 7:28. We are in closed session, only discussing those items limited to personnel matters pursuant to NMSA 1978 concerning the Marshal's Department. If I can have a motion to leave executive closed session to restart our regularly scheduled meeting.
So moved.
Second.
Motion by Mayor Pro Tem Merrick, seconded by Trustee Cadena, and if there is no objection, the time is now 7:28. From our, there is action to coming out of closed executive session, and that is for approval for the department to be, for the Marshal's Department to be having a new deputy joining us, for that being Mr. Ivan Chacon. If I can have a motion on the floor, please.
So moved.
Second.
Motion by Trustee Johnson Burek, seconded by Mayor Pro Tem Merrick. We will open it up for discussion if there is any. And seeing as there is none, Gloria, roll call vote if you would, please.
Johnson Beer?
Yes.
Yes.
Mayor Pro Tem Mayor?
Yes.
Mayor, you will call us 3 yes.
Thank you very much of approval for Mr. Ivan Chacon to be joining our department. Congratulations, sir. Deal with you after the meeting and we'll get some more details going, okay? Thank you. Next item on the agenda is Board of Trustee Committee reports. I will start with Trustee Johnson Burek.
So we had our MPO meeting, Wednesday, October 9th. You'll have to correct me, Mr. Mayor, but without, the only thing that really, and I forgot my agenda with me this evening. It's in my car. The only thing that really stands out, because, and it was such valuable information, is the safety performance standards that they presented on, and they're getting more detailed with the information. So it found it very, very beneficial. And then we did also approve, was it the MOU?
JPA.
JPA? I had a 50-50 shot.
Yes.
Yeah, we did approve the JPA. And so that's all I have.
Great. Thank you, Trustee. Trustee Cadena.
Committee reports.
Mayor Pro.
I was absent from MPO, so I don't have anything.
Okay. And my committees, I mean, I had a bunch of meetings, so let's see, where do we start? The MPO meeting with the Southwest Regional Transit District, working on their budget as well as budget updates. We did have a meeting for South Central Association of, for the SCOG, sorry. In Sunland, that was our board of directors meeting, which all of the mayors across within the region are a part of. I was giving information and updates to what's happening with the SCOG. We did have a Taylor's Friends meeting this last week, and so they're up and running with that, and the Taylor's Friends group is getting ready. Well, they have a gift shop going within the monument, and they're gonna have it running heavily throughout DL sales through that as well. I do have committees, not really committee per se, but a conference coming up for infrastructure that I will be attending with